Okay, good morning, good day, and Happy New Year to everybody. No, so I hope that ev everybody are fine for us to finish uh, the subject matter. So my discussion is all about the general considerations regarding criminal investigation and intelligence. That is chapter 2. So as you see, now after this chapter, the student will be able to discuss the importance of familiarizing the features and nature of criminal investigation and criminal intelligence. So I hope no on what is happening no in our society today in the Philippines, you are able to connect yourselves as far as the subject is concerned on the importance and significance of criminal investigation and intelligence. No, so do not forget. No, once again, the correlation of intelligence and criminal investigation. Correlation of criminal investigation and intelligence. No? So in chapter 2, we will discuss general issues that you have to consider as far as criminal investigation is concerned and intelligence. Okay? So the first topic that we will discuss is all about the two theories to protect citizens from criminal attacks. So these theories no, will broaden your appreciation on the importance of criminal investigation as far as protection of people in the society are concerned. You will try to see what are the crimes that were recently happened in the Philippines. Try to connect if there is no investigation to a certain incident or crime that happened or alleged crime that happened, then basically we will not find out the truth. Then in that way, if there is no investigation, citizens are open or vulnerable for any further criminal attack. So that is why criminal investigation is very important. So try to see this. First is one way to protect the citizen is through crime prevention. That is the first line of defense. The conduct of patrol, no, the conduct of police omnipresence will ensure the protection of the society or the people uh, per se. No, so if there is crime prevention, because the police are present in the surroundings, the police are conducting patrols, then basically that will deter a would-be criminal to commit crime because of fear of arrest uh, by the police officer present at the area. No, and other similar incidents that will protect uh, uh, the citizens. Intelligence also. Uh, the presence of intelligence, the conduct of intelligence gathering, or the process of intelligence will also prevent crimes. Because again, in intelligence, you are getting advanced information. No? So when you have advanced information that a certain group or a terrorist group, for example, wants to attack, no, or do an illegal act, then at least you know now what to do in advance, no? You conduct raid, you conduct arrest, so that these people or this group will not materialize what they are planning to do as far as crime is concerned. That is how crime prevention is very important. No. Now the second one is when there is already a crime. No. When there is already a crime or incident that happened, uh, for us to control the propagation or the continuity of a certain crime, uh, then there should be criminal investigation. There should be proper criminal investigation. There should be genuine criminal investigation. When I say genuine, the investigators have exerted 101% of their efforts, strategies, techniques, and resources, and above all, is they followed no established procedures as provided by law. So, of course, you know the purpose of criminal investigation. No, you know the purpose of criminal investigation. No, that is to identify, to locate, uh, and provide evidence to support the guilt of a person alleged to have committed a crime. So, again, by means of crime prevention, we could protect the citizen, no, through the conduct of patrol and similar activities of the law enforcement. And secondly, when there is an incident already that happened or that happened already, then uh, criminal investigation must be conducted in order to find out the truth and identify the suspect so that he will be or he will answer the charge against him. Okay? So that is how criminal investigation is important. The second thing that you have to consider in chapter 2 is the legal aspect of criminal investigation. As I mentioned a while ago, when we conduct investigation, we must always uphold the law. No, we must always uphold. Okay, so as investigators in the future, you always remember that criminal investigation is uh, it is covered by procedures, and no one is above the law. So for you to understand what I'm saying about legal aspect, when we say legal, we are referring to laws. So these are uh, procedures, as provided by law. That these are established laws that connected to criminal investigation. So legal aspects, these are laws that are related to the conduct or processes of criminal investigation. So remember, rule of law is the heart of every criminal investigation. It is not rule of law this one rule of law and not by rule by law. No, rule of law is the heart of criminal investigation process. Let me clear this out. Rule of law is the heart of criminal investigative process, because once you did not follow a certain law or procedures provided by law, then that will be a cause for the case to be dismissed, especially when the case is already in court. No? So the court will determine if the investigator, the police have followed strictly uh, the mandates of the law when they conduct investigation. No? So this one, no, do not follow this rule by law. No, rule by law may refer to uh, uh, the wish of a certain person. No? So in other words, when we say rule by law, that is not good. Rule by law is not good because you are following your own law. But what we are upholding and what is proper is we have to anchor every actions that we should do in the rule of law and not rule by law, no? So hindi dahil gusto ng presidente, dahil gusto mo, gawin mo, no? Because hindi lahat ng gusto natin pwedeng gawin because if it is not in accordance to the law, then that is illegal. No? So we should always stick on the rule of law without exception as far as criminal investigation is concerned. No? So, what are some laws that you have to follow? No? What are some laws that you have to follow? And remember, as far as the conduct of criminal investigation is concerned, the first one is the Constitution. You know, in criminal investigation, we are dealing with criminals. We are dealing with people who committed crimes. And these people who committed crimes or alleged of committing a crime have Bill of Rights. They have Bill of Rights guaranteed under Article 3 of the 1987 Philippine Constitution, specifically the rights, the constitutional rights of persons arrested, no, or detained or charged of a crime. So, in Article 3, for instance, everybody uh, is presumed innocent until proven guilty. That is one example of uh, a provision in the 1987 Philippine Constitution. One is we have the right to due process. You know? So even the evidence is very obvious, or even you are angry because you have witnessed the crime, you will not just kill someone or imprison someone or call him a criminal, but rather you have to undergo the process until proven guilty. So that is why one of the provision of the Constitution says we have the right, or everybody, or especially the criminals or person charged of a crimes or crimes are considered innocent until proven guilty. Okay? And other related provisions. No? So the Constitution is the highest law of the land that you have to follow. If you will not follow one, then basically that will damage, destroy the success of any criminal investigation. Another is, of course, that is the reason of a criminal investigation, the violation of the criminal law. The criminal law, the number one source of criminal law is the revised penal code as created by Act number 3815 as amended. We have also the 2000, so this Act number 3815 defines the crimes, no? Diyan mo makikita yung different crimes put in one book, no? Murder, homicide, theft, robbery, and so forth and so on. So that is the book of any investigator. For you to say that this is a crime, or for you to say that there is a crime, you have to refer it to the revised penal code if the elements are present before you file a necessary charge in the prosecution, no, level. Then, or even during the investigative procedures, no. Example, when you take mugshots of a person to be arrested as part of the booking procedure, you have to establish what is the possible crime committed based from initial evidence. And based from evidence, you look into the book, the revised penal code, and find out what is the violated provision. So if it is theft, then establish the article. No. Then number 3 is the 2000 revised rules of criminal procedure. Criminal procedure is a law that gives remedy if there is a crime committed. So if there is a crime committed, what will you do? What should the police do? What should the victim do? And all of these things will be in the uh, rules of criminal procedure. From Rule 1110 to Rule 127, dyan mo makikita yung mga different remedies na pwedeng gawin to claim, no? To claim your rights when it is or it has been violated, no? So yung rules of arrest, paano ka mag-aresto? Ano ang gagawin mo pag nag-aresto ka? Iyan ay nakabase sa sinasabi ng rules, no, of criminal procedure. Diyan mo makikita yan. Kung ang hinahanap mo naman kung anong krimen ang nangyari, then look for the revised penal code, no? Kung gusto mo namang tignan kung ano yung mga rights na dapat i-observe and irespeto natin sa mga taong gumawa ng krimen, no, or alleged to have committed the crime, then we should always observe the Philippine Constitution, in particular Article 3. Then, of course, when we are talking about evidence, paano mo i-handle ang ebidensya hanggang sa presentation sa korte ng mga evidence, ano ang mga klase ng evidence, then refer it to what law it is the rules of criminal evidence from Rule 128 to Rule 134. That is a revised rules, May 1, 2020. Then we have also special laws because hindi lahat ng batas ay nasa revised penal code or constitution. There are other laws or procedures or even crimes that are provided by special laws. So, special laws meaning specific laws. So kung ano ang krimen na wala sa revised penal code, nasa special laws. Kung ano ang mga procedures na wala sa rules of criminal procedure or evidence, nasa special laws. Ang example ng mga special laws, these are laws created by Congress of the Philippines. Ano mga example? Republic Acts. No? So what are some examples of Republic Acts or special laws that are related to criminal investigation? We have Republic Act number 7438. Yan ang parating isipin mo as investigator. 7438, that is the law that defines statutory rights for persons arrested, detained, or under custodial investigation. Let me just say you one. No, as I mentioned before, when you arrested a person, this law says, in all courses, lahat ng proseso na gagawin mo sa isang person na naaresto or iniimbestigahan mo, kailangan he must always be assisted by his counsel. Counsel of his choice or a counsel provided by the government if the person arrested cannot afford to provide one. So, yan. Lahat ng gagawin mo, kailangan he is assisted by his counsel because his counsel is guaranteed by law to protect his rights against any abuses by the law enforcers or investigators. Okay? So you have to understand that. Another, when you arrested a person or when you invited a person, a suspect or witnesses, do not force them physically. No, in the early times, they have to exert painful processes just to force the person to talk or confess to a crime. So because of that, the Anti-Torture Act of 2009 has been established or erected in order to punish those authorities who commit torture, especially during investigation, as a crime. So torture is a crime. Then Section 29 of RA 9165, remember this, especially today, that drugs is a popular crime that the law enforcers are focusing on. Uh, Remember this, as a law enforcer, as investigators, if you planted evidence just to arrest a person or just to gain record or promotion, then once it has been proven that you have planted evidence, uh, then especially drugs, then the penalty in the law before is death, but now it is the highest penalty that will be given to you, reclusion perpetua in exchange of death. So yan, section 29. So do not plant evidence just to arrest a person. That is what we call planting of evidence. No, that is planting of evidence. In other terms, is instigation. Instigation is illegal. Ano yung kapatid ng instigation? Entrapment. No? Entrapment is legal, instigation is illegal. What is instigation? Planting of evidence. What is entrapment? That is a lawful process conducted by law enforcement officers to quote a person in the act, kaya entrapment. Ano ang pinakasikat na example of entrapment? It is called buy-bust operation. No? Buy-bust operation. Paano ginagawang buy-bust operation? A pusher, P-O-E, pusher, buyer, pusher buyer, no? Ay, yun ang tawag sa isang police officer or law enforcer who will act as a buyer, pusher buyer ang tawag. And they will quote the person in the act, no? Yan yung in flagrante delicto. Yan, pag sa buy-bust operation, you can arrest a person without a warrant because he committed the crime in your presence or in flagrante delicto. Then RA 1405, when it comes to investigation of bank-related crimes, like money laundering, always remember you cannot force the banks to disclose or produce information about a bank records because RA 1405 prohibits or punishes disclosure, illegal disclosure, or inquiry into deposits of people. So that is the bank secrecy law. Then also, in the gathering of information, like in the conduct of intelligence, surveillance, it is also prohibited to illegally listen or wiretap, to listen to private conversation through online or through telephones, any private conversation. It is illegal for you to listen or secretly listen to their conversation. So bawal ang wiretapping, no? Because it is provided and penalized and prohibits by RA 4200. Another is the PNP Revised Criminal Procedure Investigative Manual, revised 2011 for the PNP. Yeah. And the PNP Revised Police Operational Procedure, revised 2013. So these 7 cited laws and procedures must always be remembered by an investigator, that he must always follow them, or else the result of the investigation will be useless if he will not follow them. Okay? Then next issue is the legal doctrines in criminal investigation and procedure. No, legal doctrines in criminal investigation. These doctrines, these doctrines are guides, legal guides for people to understand the law. No, so if you are an investigator, understand these doctrines because they will guide you in the implementation of the laws. So where first is doctrine of actio personalis moritur cum persona. This means in Latin, personal action terminates or dies with the person. So pag namatay na yung akusado, for example, or suspect, then there is no more chance to continue the investigation. It is already done. No? Okay? So wag niyong hintayin mamatay yung tao, hindi mo pa na-establish yung kanyang guilt. Wala na. Okay? Then just like the Ampatuan case na marami nang namatay na akusado, hindi pa natapos. But of course, tapos na yan, if I'm not mistaken, last year. The doctrine of adherence to judicial precedents, also called the doctrine of stare decisis. So itong doctrine na ito requires courts in any in a country like the Philippines to follow the rule established in the decision of the Supreme Court. You know, this means kung merong decision ang Supreme Court, nagiging parte yan sa interpretation ng batas natin. Yan ang tinatawag ng jurisprudence, no? So, kung may kaparehong kaso ang hinahawakan sa anumang korte, no, kapareho na kaso, then pwedeng ibase doon sa naunang decision ng Supreme Court, ibase doon yung decision sa kasalukuyang kaso. So, example, no, sa checkpoint, but this is not in relation to the doctrine, but this is in relation to my explanation. Example ng application nito, no? Bawal pumasok or bawal lumabas, no? Pero that pinalabas ang isang tao, no? Pero nung ikaw ang gusto mong lumabas pero ayaw kang palabasin, pwede mong sabihin, bakit yung unang tao na yan nakapareho kong nangisit ay pinalabas ninyo, bakit ako hindi mo pwedeng palabasin? That is why kung ikaw yung nagpalabas sa tao, kailangang isipin mo, ay, pinalabas ko yung nauna, kaya kailangang palabasin ko rin ito kahit bawal. Kasi yung una kong decision ay pinalabas ko. So it follows sa mga ibang the same na decision, kailangan nakabase din doon. So going back to this stare decisis, whatever the decision of the Supreme Court, the other courts in whatever decisions or cases that they have, so long as it is the same, then they can interpret it the same. Okay? So yan ang stare decisis. Okay? Then doctrine of command responsibility. This is common, no? You know, in every police station, in every unit, you have your heads. No? Sa investigation, may team leader. Sa police station, may chief of police. So pag pumalpak ang ginawa ng mga tao mo, then basically, you have a command responsibility. So that is why, to all heads, or kung ikaw ay team leader ng investigation na yan, then kailangan gawin mo at imando mo ng tama yung mga tao mo, or else pag nakamalian, pati ikaw ay madadamay. Okay? Then next is doctrine of constitutional supremacy. Supremacy. If law, a norm of the Constitution, you know, this means only that the Constitution, as I mentioned, is the highest law of the land. It is the mother of all laws. So kung isang batas na ginawa ng Congress ay conflict doon sa sinasabi ng Constitution, then ano ang susundin mo? It is the Constitution. Next, doctrine of interlacing confession. Interlacing confession. This means that extrajudicial confessions independently made without collusion, which are identical with each other in the essential details, are corroborated by other evidence or record, are admissible as circumstantial evidence against the person implicating or implicated to show the probability of the latter's actual participation in the commission of the crime. So this is an extra, we are talking about an extrajudicial confession. So pag sinabing extra, this is a confession made by an accused outside court. So example, during interrogation, nag-confess yung tao na yan, that is extrajudicial confession. No? So, interlacing. So, sabi niya, pag may dalawang confession, so long as it is on record, it is still admissible. Okay? Then, pakibasa na lang yan. Doctrine of Judicial Admission. This is, this cannot be contradicted by the admitter who is partly himself and binds the person to make the same. Okay, so the doctrine of judicial admission says that if once you have made your admission, no, once you have made your admission, especially in court, no, that you have committed the crime, then you are not allowed to contradict it later, no. Pag ikaw gusto mong bawiin yung sinabi mo at nasabi mo na noon na inaamin mong ginawa mo ang krimen, then hindi na pwede yan, no. Kung such as that's move, no, nagawa mo na yan, unless if you will prove in court that you made your judicial admission through palpable mistake. Okay. Next is doctrine of jus sanguinis. This means in Latin right of blood. This is a principle of nationality law by which citizenship is not determined by place of birth, but by having instead one or both parents who are citizens of state, or more generally by having state citizenship. Yeah. This means only that so long as one parent is a Filipino citizen or a citizen of the country, then still the person is a Filipino. So, for example, in the Philippines, your mother is a Filipino and your father is an American, then basically you are still a Filipino by blood because one is a Filipino. So it does not mean that kailangan dalawa, no? The parents are both Filipinos. No? Okay? This is applied not only in the Philippines but an international doctrine. The doctrine of parents patre, nai-apply ito especially to minors. So in the case of children in conflict with the law, or in cases of child abuse cases, then if a minor have no parents, or the parents are not qualified to have their children in their possession, then the country or the state or the government will enter as parents of these minors, okay, or as guardians. The doctrine of Prorayo, this means that an evidence on an issue is found in question, or there is a doubt on which side the evidence weighs, the doubt should be resolved in favor of the accused. No? So if there are two evidence that are conflicting with each other, then you will choose the evidence that is in favor to the accused. No? Okay? So pag may black and white, then basically pipiliin mo yung white at yan ang favorable sa akusado. No? So when you weigh evidence, there are two different evidence that are conflicting with each other, then choose the evidence that is favorable to the accused. Pro. Doctrine of proximate cause. This doctrine, proximate cause, state that proximate legal issues or cause is that acting first and producing the injury either immediately or by settling other events in motion. Proximate cause states that If you are the cause of the cause, then you are the cause of the evil cause. No? So in investigation, try to establish the proximate cause. No? Yeah. Just like in the case of the Zera, try to see, no, who caused the evil cause. Sino ang pinakadahilan kung bakit or pwede siyang namatay. No? So, you have to establish the proximate cause. No? Ang pinakaugat, no? Kung paano nangyari sa isang tao ang bagay na hindi maganda. No? For example, in an example, without any intention, uh, tinatakot mo ang isang tao, no? Nilagyan mo ng langgam yung kanyang bag, for example, as a matter of joke. Pero siya pala ay takot na takot sa langgam, then in that way nakita niya namatay, then you are the proximate cause of his death. No? Na kung hindi sana dahil sa ginawa mo, hindi sana siya namatay. Yan yung sinasabi ng proximate cause. Then Doctrine of Res Gestae, you read that? That is when it comes to evidence. Now, doctrine that is recognized as an exception against hearsay rule. No? So, ito yung exception sa hearsay rule. No? Pag may narinig ka, sa example, nasa isang kwarto, narinig mo na sabi niya, patayin kita, Juana, nasa isang kwarto lang yon, then pwedeng ma-accept yan as evidence to prove na si Juan ay siya ang pumatay dahil narinig mo siya na sumigaw sa isang room na gusto sabi niya, patayin kita, Juana. Then afterwards, may namatay na si Juana, then basically you can use that na narinig mo pero hindi mo nakita. No? That is an exception to the hearsay rule or evidence. You will learn them later as you go on. The doctrine of res ipsa loquitur, that is very basic. No? Pag may baril sa crime scene, no? May mga empty shell or cartridge cases at the crime scene, then basically from that point you can establish that the possible weapon used to kill or injure the victim might be a firearm. No? Huwag mong sabihin baka pinoison or baka sinaksak. No? The evidence itself speaks itself. No? So the thing speaks, or the thing itself speaks. Okay? Then Miranda Doctrine, that is a very important one, especially in the conduct of arrest, investigation. Miranda Doctrine, you will read that, no? Galing yung term na Miranda na yan is the name of a person accused in America. Ernesto Miranda. Pakibasa na lang yan. So ano yung mga common Miranda Doctrines that you have to observe so that your case will be successful as far as arrest, for example, is concerned? You have to inform of the rights. No, this Miranda Doctrine provides you have to state the rights of a person to be arrested or detained. So what are the rights na kailangan mong sabihin at ipaintindi sa tao na gusto mong i-custody or arrestuhin? Right to be informed of the nature of the accusation, the right to remain silent, the right to have counsel. Yeah. So you have to state these rights in a language understood by him. Then the last one is exclusionary doctrine. Yan. yung sinasabi natin, if you do and gather evidence illegally, kung ano man ang nagather mong evidence illegally, then it will, again, it will become illegal. So if it is illegal, then it will not be admissible in evidence. Okay? So you have to follow the law, or else that the evidence that you gathered will become a fruit of the poisonous tree. Okay? Doctrine of warrantless arrest, tatlo lang yan. No? Basahin nyo. Hot pursuit, no? Then, in flagrante delicto, when in your presence someone have committed the crime. The second is with personal knowledge, no, of the crime and the suspect. Immediately thereafter, you conducted follow-up operation to arrest him. Then that is hot pursuit, no. Wag mong patagalin ng 1 week. That is not already hot pursuit. Then when the person to be arrested is a prisoner, yan, or escaped prisoner, pwede mong arestuhin yan. Pwede rin yung mga tao that have violated their the condition of their probation, the condition of their parole, pwede mo silang arestuhin without a warrant of arrest. And those also foreigners na may kaso in relation to immigration law, you can arrest them after a process is done. Then the Plainview Doctrine, no? This is especially when you are seizing, no, evidence, no. This Plainview Doctrine states that an officer, no, have the right to seize and seizure evidence without only plain view that you will use, no touch, no. So for example, when you conduct search of a motor vehicle, no, search of a motor vehicle, you are not allowed to force and open compartments, no, but rather use your eyes. So kaya nga pag sinabing Plainview Doctrine, by using your eyes or vision, you can look of the things that are within the area for you to detect if there are illegal, no touch, no. So that is the point of Plainview Doctrine. Okay? Then basahin nyo na lang yan, yung Plainview Doctrine, so that you will further understand. The Doctrine of Hot Pursuit. Yan, parehas lang doon sa taas, no? Sa in-explain natin doon sa warrantless arrest. Okay? Then those are some of the doctrines that you have to remember. Okay? So thank you, and we will continue our discussion.